Good morning, and thank you so much for the opportunity to testify, Chair Dinowitz. My name is Albert Fox Cahn, and I'm the Executive Director of the Surveillance Technology Oversight Project, a New York-based privacy and civil rights organization. My testimony today will be a shorter excerpt of the written remarks that will be entered into the record. I've been a proud member of the New York State Bar for my entire legal career, but today, sitting here thinking of how we have mistreated recent law school graduates, I am embarrassed. I am embarrassed of the fact that we saw COVID-19 not as a chance to revisit the ways that the New York Bar has systematically failed law school graduates for years, the ways that it has failed to live up to its stated purpose, but instead we use biased, broken, and invasive surveillance tools to prop up the discredited remains of this long unnecessary test. And specifically, I want to respond to some of the issues brought up by John McAlery. When asked about how the massive amounts of biometric data collected on examinees, including hours of audio and video footage, were being safeguarded by ExamSoft, he didn't have any details. He didn't tell us what encryption they used. He didn't tell us about their access controls. He didn't tell us about independent auditing by third-party cybersecurity companies. He told us nothing, simply that he trusted them to be secure. Well, I need more than his trust. I need to actually know what is being done to safeguard the information from examinees. And he also assured us that if he received a subpoena from law enforcement officials, he would refuse to comply under New York law. Well, that's fabulous. But what about ExamSoft? They can receive that same subpoena. Will they take that same stand? What about this if they receive a warrant from federal law enforcement, such as ICE? Under those circumstances, it's unclear if New York's legal protections would actually block compliance with a federal court order demanding the hours of footage. And this, to me, is so very offensive because we have asked thousands of New Yorkers who are applying to become a member of this bar, who are being tested on the Fourth Amendment and criminal protections, to effectively consent to a government wiretap in their home, to hours of recording that then are vulnerable to criminal process. Also, we have to identify the risks with using artificial intelligence, particularly facial recognition. This software has time and time again been shown to be more error-prone for people of color, particularly Black women. This means that sometimes we've heard horror stories of African-American women having to shine a light in their face during exams just so that the computer software could see them as a human being, so it could recognize them for who they were. We don't have information about the error rates for ExamSoft's facial recognition technology. We don't know if it has higher rates of false positives for African Americans and Latinx New Yorkers, as we have seen with so many other commercial facial recognition programs. With artificial intelligent movement analysis, you are essentially making differences into something that is suspect, and you're making disabilities into a crime. You're telling people that they will be flagged simply because their movement patterns are different from what is considered quote unquote normal. This is antithetical to the values of our legal system and to the values the bar claims to uphold. We've heard horror stories of test takers having their identities stolen, having their credit card information stolen, being contacted by proctors on social media after taking exams. Thankfully, most of these horror stories have played out in other jurisdictions, but the underlying vulnerabilities of the software remains. This is a broken and discredited model. We need to grant diploma privileges to recent graduates. That is the only approach that is just, that is equitable, and is in alignment with the values of the bar. There is absolutely no evidence that asking individuals to answer multiple choice questions, closed book, based on rote memorization has any connection to the practice of law. These are tactics that would get you disbarred if you were an attorney and attempting them in real life. And we are simply holding on to them because we haven't reached consensus about something better. Well, we need to. And until we have an alternative that is evidence-based, we need to suspend the bar exam and allow diploma privileges. I thank you again for the opportunity to testify, and I look forward to answering your questions.
Okay, thank you very much, Mr. Cahn. I see one hand, and that's Ms. Simon.
Thank you. Thank you, Mr. Cahn, for your testimony and for the work that you've been doing. I understand that there was initially a concern that there would be, that the artificial intelligence would be actually scanning the room in the individual's home when they were taking the test. And then that was clarified, I believe, by the bar examiners when I reached out to them about that. Does that change in any way your view about the sort of surveillance aspects of this and the sort of warrantless search aspects of the administration of this bar exam to people remotely?
It really doesn't. And we heard from Mr. McAlery earlier that they are reviewing thousands of hours of footage. That you have unidentified, unnamed members of the Board of Law Examiners looking through hours of footage of people's bedrooms, of what's going on in their homes, conversations from nearby loved ones. This is the most invasive model I can imagine. And even if the artificial intelligence component works as advertised, even if it isn't discriminatory, and those are big ifs, this is still acquiring huge amounts of information that should be protected and really subjecting examinees to a level of outside monitoring that is completely unjustified. And one thing I would be remiss not to note, this is using the exact same facial recognition technology that this assembly voted to outlaw for K-12 education in Assembly Bill 6787D. That was passed earlier this year. That's still awaiting the governor's signature today. And if that's something that's inappropriate in K-12 education, why should we be subjecting bar examinees to that exact same technology now?